going to occur within the community. And I appreciate not only the individuals on the panel showing up, after a long, hard day of work, but I also appreciate, the turnout here. This is very encouraging. I wanted to acknowledge the Depression and Bipolar Support Alliance folks that are in the audience, the board members, if you could just raise your hand. And then also there's individuals where we, DBSA partnered with NAMI, and there's NAMI board members that are here as well, so if you could raise your hands. Great. So thank you again. So I think I'm going to just sit down. Just make it
everybody else is. Why?
I won't tower over folks. So tonight, the topic of tonight's forum is how the system functions when an individual is in a mental health crisis. So we have a panel of experts that can give different perspectives on that. And starting on this end and then going down to the other end, I'll just give a brief introduction. There's Sheriff Ty Trenery, and there's Corolla Schmidt. The sheriff is actually with the Snohomish County Jail, and Corolla Schmidt is with Snohomish County, I got it right here, involuntary treatment. Okay, then we have Ed DeProd, that is the jail medical department health administrator with Snohomish County Jail. We have Judge Tam Bowie, is Snohomish County Mental Health Court. And then we also have Judge Laura Van Slyke, which is the City of Everett Municipal Court Community Justice Alternatives Calendar Judge. So what I'd like to do now is just go over a couple of housekeeping things. We have essentially 90 minutes together for this presentation. First off, probably one of the more important things are the restrooms are back there through the door in the back there. What we'll do in terms of an agenda is we'll do some brief introductory piece with each of the panelists, and then we'll provide some questions that are kind of set the foundation for some common understanding. We'll engage with each of the panelists on that, and then we'll wrap up the evening by 8:30, but we want to have ample time for the audience to ask questions. And we'd like to have those questions come at the end so that we have ample time to kind of lay down that base understanding. So one thing tonight, we're going to focus on adults in this forum. There will be, hopefully, this will be a spin-off for future discussions within the community. And I kind of see this as the first of many, and we may engage with any of the panelists individually in the future, but tonight's focus will be on adults, and in the future we'll hope to have a forum that will focus on juveniles and adolescents. So one thing I'd like to point out too is that this event is being recorded tonight. So it will be accessible on the Depression Bipolar Support Alliance YouTube channel, and it also available on their website. There also may be media reporters in the attendance tonight too, so you may be approached for your thoughts on the event. Also, a final housekeeping thing, I'd like to encourage everybody to sign in. So there'll be a sign-in sheet that will be circulated about. So I'm just real briefly, I'm the current president of NAMI. My name is Keith Binkley. I'm just returning from vacation, so I'm in transition. But I kicked off my vacation a week ago Friday, and I attended a conference on mental health at Saddleback Church in Los Angeles. So this was, the point being, it's amazing what you can accomplish when you get the right people in the room together. So this conference was 3,200 people attended from across the country. It was held in Saddleback Church, and they were churches, church leaders, a third of the audience was church leaders. So they were really coming together to address mental health in the church context. So it was really a rally, and at a very big church. And it's just a sign of, we're in an era where we're finally moving to address challenging issues in a more compassionate way. And that's very exciting. So with that said, I'd like to run down the line here, starting with you, Sheriff. And I'd like you to give a brief introduction of yourself, what your role is in the community, and for situations where you engage with somebody with a mental health challenge, how your paths would cross there, and any developments or trends that your department is for.
Thank you, Keith, and I'll take key on the emphasis brief, because I could go on and on and on all night long. Good evening, everyone. Thank you very much for being here tonight. Again, my name is Ty Trenary. I'm your current Snohomish County Sheriff. I've been in law enforcement for over 25 years. I grew up in the Tacoma area and moved up here in 1991. I actually started law enforcement in a really small town, which I think is really key, quite frankly, in law enforcement. It's really interesting to have to work in a community where the guy you write a ticket to on a Wednesday night might be the same guy that helps you out in a bar fight on a Friday night. And everybody should have to start law enforcement that way. My background is I've worked in almost every facet of the sheriff's office. The two parts that were best so far for me was assigned to a new unit in the early 90s called community policing, and it was really good for me because it thrust me into not the typical type of law enforcement that I had kind of become accustomed to. And then as I promoted up to the ranks when I made lieutenant in 2008, I had the opportunity to go to Stanwood, which is one of our contract cities, and be their police chief. Best job I've ever had. Great community. My wife at the time was a school teacher up there, and our two daughters were going to school. They hate it when I tell the story, but any boy that wanted to date them had to come by the PD and meet with me. And they blame me to this day that the fact that they're not involved in a meaningful relationship, but it was great. When I had the opportunity to be appointed to sheriff in July of 2013, candidly, when the council asked me what I knew about corrections, I really said I don't know anything. My role has been on the law enforcement side of the house, and really all I've ever worried about was when do I get my handcuffs back. And I'll tell you that has really proven itself to be a monumental challenge, because if you've heard me speak before, you know one of the things I say, I get very passionate about, is the fact that we've used our jail for 17 plus years as the largest mental health facility we have in Snohomish County. And it wasn't designed to be that way. It's not staffed for that. And for all of the wrong reasons, we continue to use it to be that way. And we're paying the price for it, in my opinion, as a community. I think that criminal justice, you're going to hear criminal justice talk. We are changing the way we look at it. There is no magic pill. There is no one funding solution. I don't believe that we can all pay $59.95 a month on our Visa card to fix this problem. It's going to take comprehensive reform. We recognize, I believe, in law enforcement that the solution to the homeless individual on the street corner that makes us all uneasy is not finding a reason to arrest them and put them in our jail. That hasn't worked. And quite frankly, we need to stop doing that. Ken Stark, and I don't know if Ken's here, I know Cammie is, they've done marvelous things with really partnering with the criminal justice side. So Ken is our human services director to look at what can we do differently. Judge Bowie, I don't want to steal any of her thunder, marvelous in terms of trying to take mental health and treat it for what it needs to be treated for, instead of being seen as a reason to arrest somebody and put them in jail. So just real quickly, because I said I'd be brief, and I think Keith's looking at me. We're really on a very long-term strategy. The things that we have been able to do quickly is to try and change what we do at the jail. So screen folks the minute they come in the door. That's been very helpful for us. Before, it was taking us a long time to get to folks, especially with mental illness, but just as big as mental illnesses for us, so is opiate addiction, and candidly, sometimes they're combined and they create great problems. So we're trying to identify those folks the minute they come in the door. Secondly, we've greatly improved the amount of training we get. The comment I made earlier about, the only thing I knew about what a jail was when do I get my handcuffs back. We can't arrest our way out of this problem. And so we're working really hard with Human Services 1/10 board to update our training. There's a 40-hour class called Crisis Intervention Training. It's marvelous, marvelous training. And my goal is to get every single police officer in this county trained up in that. I could talk about that all night long, but it's one little story. Is I sent one guy when I was in Stanwood kicking and screaming to this class, and he came back a completely different officer, and really was the catalyst for me getting additional officers to attend. So, and then the other thing that we're working on very diligently is to get all the custody deputies a piece of that training as well, so that they get an opportunity to see how to deal with mentally ill folks that isn't the traditional way that we would deal with somebody. That's one little tiny step that doesn't solve the whole problem, but I think it's focusing on the fact that, once again, the jail shouldn't be our mental health hospital. So I'm going to shut up after that. Thank you.
Thank you.
Hello, my name is Carola Schmidt, and I'm the manager for the involuntary treatment team. And there's two managers. Angie Jorstad is the other person, so we manage involuntary treatment and then the community mental health program.
Can you speak up a little bit?
Sure. Like jail that's fine. Yeah. Jail transition services, and we have a couple other mental health people we supervise. So I've been in this capacity for the last 4 years. I think I've been the manager. I started with Snohomish County in involuntary treatment in 2000, and before that I was with Compass Health on the voluntary crisis team, I think since 1994. So I've always worked in crisis intervention since graduate school. And I supervise the people who conduct investigations for involuntary treatment, so for the initial 72-hour hold. And then we stay involved after that, conduct the possible court hearing or testify in that court hearing, and work with the psychiatrist at the facility and then with the prosecutor and public defenders on each case. We interface quite a bit with the jail. We do a lot of evaluations in the jail and then out in the community, emergency rooms, and other community settings.
Hi, good evening. I'm Ed DePra, the Health Services Administrator at Snohomish County Jail last 6 months. So when Ty gave me this opportunity to come on to Snohomish County Jail, I had already been working in the jail for a little over 3.5 years, and I was seeing the issues left and right, issues where there was lack of follow-through on psychotropic medications, getting confirmed, verified, and then brought to the inmates in a timely manner. I saw many cases where we'd have Axis 1 diagnosis, the bipolar, schizophrenia, etc., languishing in a jail cell for 23 to 24 hours at a time. And I really took it upon myself to see this as a gift to really reach out and help those that could not voice or were not heard when they were voiced, for aid, assurance, confirmation that they would get through the process. The jail, especially max house settings, which we call it, these 23-hour lockdown areas, are very dark, dungeonous places. It's no place that I'd want a son or daughter or even myself to go through, and I just can't imagine going through that without my medication, or without my case manager, or without my mother, father. It's heart-wrenching at times for those 3.5 years to see that. So I'm very thankful that I've had this opportunity, and we've done many changes in the last 6 months, very short amount of time, to confirm meds, attempt to see every single inmate before we lose a arresting officer and or they leave the booking area, to confirm medications, to meet with them one-on-one, to assure them that medical is following up, to assure them that a mental health professional in the jail has been notified that they're in the jail. Then, when they get in through the module, that anxiety, that angst has been just naturally brought down a couple levels. there's many more things that we have planned, many more things that we need to do, but it is a community issue, as the sheriff said, and I'm glad I'm at the forefront and part of this to help everyone that has to go through this process. Thanks.
Question, why are you giving them psychotropic drugs? Why are you giving them drugs at all?
We can talk about that during the question and
I
answer
was just
time.
wondering, because drugs have never cured anybody with mental illness.
Sure. And during the question and answer time that Keith will facilitate, or even after, sir, we can talk about it.
My name is Tam Bowie, and I am a district court judge. I was elected in 2006 and took the bench in January 2007. I am the judge presiding over a mental health court pilot project. It's a pilot project that started in October, beginning of October 2012, after a year and a half of many entities, collaborations, and meetings. And we started the pilot. And just some basic, it's a program where defendants who have criminal cases are diverted to mental health court. It's a problem-solving court or a therapeutic court in that we process these cases very differently from the traditional criminal cases. It's, you can think of it as an exit off the freeway. These individuals go through the prosecutor's office. They get the say in terms of whether or not the individual has a type of case or is a person that is legally eligible to enter into mental health court. And then after we get that particular green light, then the individual goes through a screening process where they get assessed by a mental health professional. And then the individual goes through it's a 2-year program. It's divided in 3 phases, and all this is written down in a protocol that is up on the court's website. It's a problem-solving court in a sense that it is intense supervision through modes of treatment, regular court sessions, and the individual is expected to meet certain goals in each phase, and each phase builds upon each other. We've had, since October 2012, we've had about 65 referrals. There are 14 pending, 14 active participants. We have 19 pending, which means that they are waiting to see if they get accepted. And it's a rolling acceptance rate because as cases go through the criminal system, and then these cases will be looked at and reviewed to see if the participant is an appropriate person and is an appropriate case for mental health court. That's, I think Mr. Bingley touched upon the development trends. One of the development and trends that the court sees is that there's been an increasing public acceptance of let's divert or think of alternatives of how we treat cases and process individuals with mental health issues, because the traditional processing of these individuals may not be the most effective. And that is the trend that the court sees as more of these problem-solving and therapeutic courts.
Hi, everybody. Can you hear me okay? I'm Laura Van Slyke, and I'm one of 2 judges in Everett Municipal Court. And I was just elected last November for my first term in that court, which will run for 4 years from January. So I've been on the job a huge number, 3 months. But Judge David Mitchell retired, and he was the judge at Municipal Court who really pushed for not a full-on mental health court, but a therapeutic court session that we have once a month that's called our Community Justice Alternatives Program. Many of the participants do suffer from mental illness, and not all of them do, though. And what we rely upon is are just using different strategies to help resolve problems. So it is a therapeutic court in that sense. We try to promote public safety in that way, and like I said, we use different strategies in order to do so. Some of them that I wrote down that I think are important for you to know about are, we don't remove accountability, but we do provide an alternative. We use a team to help make recommendations without restraining judicial authority. Importantly, we're trying to become more and more familiar every day with the community resources that are out there for folks and how we can deploy those in a meaningful way to help people get back on track and stay there. I mentioned the supportive environment. I think that it's a lot less frightening for people. I don't know if any of you have ever been to a busy municipal court calendar. I'll sit down at my computer in the morning and pull up my cases for the day, and it's no surprise at all that I'll have over 200 cases for that day. These are big, fast, busy calendars, and you know, I would be terrified coming into my court, quite frankly. I mean, you try to be as gentle as you can with people in the traditional sense, but it just can't happen with that volume. Having a smaller court where people are able to just be more in a conversation with me than the traditional back and forth between a judge and a defendant, I think is really important. And then finally, we use individualized rewards and sanctions for each of our participants. We have just over a dozen at this point. So what we do, we're similar pattern to mental health court in that we start with much more structure and high level of monitoring in an attempt to break patterns and get issues addressed. And then we try with positive reinforcement to get people positioned for the future and move them along the continuum to more self-regulation. I've got 25 years in criminal justice. I've been a public defender, I've been a prosecutor, I've been a legal advisor to the police department. I've addressed a whole host of public safety issues. And I have to say that even with that background, there are difficulties. Lawyers are not, you know, we don't have expertise in these issues. And that's one of the things that I'm really excited about in being here, is to reach out to people who I consider the experts in the field, really, who can tell me what they're going through or what they know about or how things present to them. Because it's really important that I stay on a learning trend with that. I certainly don't profess to know everything about it. So I find that that's difficult, and I certainly do my best, and I rely heavily on my team. But I also will be relying in the future on getting information coming in so that I can become more familiar with this topic, and I certainly realize how important it is. I think the only other difficulty is, you know, we try to maintain flexibility with our participants. What is success for any one individual is not necessarily cookie cutter for the other people. But you also have to be consistent. You can't treat people differently. So we try to find that balance. But I find it a very rewarding experience. I took over all of Judge Mitchell's calendars, and if anyone asks me what my favorite one is, I'd have to say this one, because it is very meaningful work. And thanks for having me here tonight on the panel.
Excellent, thank you. So now what I'd like to do in the next part here is I'd like to just circle back and pose a few questions to the panelists that kind of lay the foundation for just some common level understanding. So this first question is for you, the sheriff, and then also for Carola Schmidt to address, and it's basically what to expect when you have to call 911 on a family member in crisis.
So it's a mess, if any of you came tonight expecting a victory lap from this panel, that's certainly not what we're up here to do. We have a long, long ways to go and a lot of work. And you're going to hear me say this as long as you let me sit up here. This is a comprehensive problem that doesn't start and end with law enforcement or with the courts or with mental health or with the hospital. We have been ignoring this problem, been hoping it would get better for many, many years, and now we're paying the price for that. So back to the question, what do you expect from law enforcement? there is no one standard response because, as many of you know, mental illness is not one category. So it really depends upon the information that we get in the 911 call. In most cases, it's a family disturbance. We get a call to 911, there's been something going on in the house that's triggered an episode, triggered an argument, and so because domestic violence is one of the most violent things police officers respond to, our guard instantly goes up. And it doesn't go up with the idea of creating peace in the home, it goes up with, we know more officers are killed annually by responding to domestic violence calls than they are any other call. So unfortunately, what happens is when we show up at the house, if that's the call we've gone to, and I've picked that because of all of them, it fits the parameters, we often show up with a mindset completely different than what you expected. You called us because you have a long history with a family member, you were looking for some help. In most cases, you've tried everything else, and this is a desperation plea. And what happens is we show up with the mindset that we've got a husband and wife or brothers or a spouse, child, who are fighting with one another, and we're concerned for our safety. That typically doesn't go well. Because what happens is we're looking to see if a domestic violence law has been broken. We're mandated in this state that if there is we're told that an assault occurred, and an assault in this state is defined by unwanted touching, and it's through some type of domestic relationship, mother, son, brother, spouses, dating relationship, 16 and older, we're mandated to make an arrest. And in most cases, going back to the example, and I'm sorry to make this so painful, you all called because, or the family called because they were hoping that we would be the last piece of hope. And what we end up doing is making an arrest. And that starts this downward spiral. Now, in many other cases, what happens is we do nothing. Because in the state of Washington, for us to take somebody's freedom away by taking them in, placing them in custody to get an evaluation, we have to meet the threshold of imminent danger to themselves or others. And it's one of those things I believe we have got to change as a state moving forward. We've got to have some leeway to be able to allow families to say this has been an ongoing pattern, and you've worked with counselors, you've done some other stuff, and now through the culmination of several things going on, you've reached out to us for help. Here's what the system's supposed to do, and here's what we're working toward. And I'm gonna give it to Corolla because she wants me to shut up.
You're doing good. We're all ears.
We have the triage center here in Snohomish County. Was designed for the family member in crisis, for us to be able to take them to the triage center, try and get them some help, whether it's through counseling, through medication, a combination of both, and a plan. Very often we fail to use that facility, and that's on law enforcement. We have failed to understand what that facility can do. One of the things I've listened to all the police chiefs do, I know we're doing in the sheriff's office, is since February, we're requiring every patrol deputy to go and tour the facility and spend part of a shift working in there. And I called today because I knew this question might come up. We've got 75% participation within the sheriff's office. What we've done in the past is you call us, it's not something for which we can make an arrest, there's problems, something needs to be done, so then we call an ambulance. We call an aid car to come, and we ask the aid car to transport the family member to the hospital, hoping that when they get to the hospital, they'll see somebody that can provide them with the necessary stuff. And that doesn't happen either. In fact, what happens is the hospital works very quickly to move them out of their facility because they've got bed space issues. And so the real solution for me is using the triage center better and having our folks trained better to understand that this isn't necessarily the domestic violence call for which we've been trained, but it's more about a family reaching out to us because they've tried everything else and we're the last stop. And very, very often we forget that.
Okay, so I will answer the question from the perspective of what happens if you encounter designated mental health professionals. We're generally not the first ones on the scene. We do go out with law enforcement, but I would say most of the time you will see us in a different setting. Either, we've been called to the family home or to a community setting or the emergency department. We get dispatched by the crisis line. sometimes by police, and we also get called over to the jail on a regular basis. And our threshold is a little bit different from what you just said. So for us, we're looking at also if somebody's in imminent danger to themselves or others, or somebody else's property, or if somebody's gravely disabled, meaning they can't care for themselves for their essential needs of health and safety, food, shelter, and so forth. However, the statute also allows for what's called a non-emergent detention. So just like the case that Chief Turner was illustrating, where you've dealt with a family member for a long time, they're slowly deteriorating. We probably couldn't establish imminent danger, but we all have a pretty good idea that this is not going to end well, and we also have some history where the person really ended up in a bad situation. And then we can file a petition for non-emergent detention, put that in front of a judge, and then if the judge grants us an order to detain, we can also place the person in the hospital on a 72-hour hold. So we don't necessarily have to prove imminence. So that's important to remember. There's really both parts in the statute. The law we follow is RCW 7105 for adults and RCW 7134 for minors up to the age of 18. Is there any, should I go into more detail, or is that good for basic intro, or?
Yeah, I've got a question here. What is the process and criteria for getting your family member evaluated for possible inpatient involuntary treatment? But it sounds like you touched largely on that. I don't know if you have anything additional to that.
So I think you would call the crisis line, and they will ask you a certain set of questions as to what's going on. They will definitely always ask if the person is willing to engage with a mental health professional. Washington is, as I'm sure you're all aware, definitely errs on the side of civil liberties, where if the person is willing to accept treatment, that we will not be involved. There's a strong belief that we shouldn't come in, read somebody their rights, and present them with an involuntary commitment evaluation unless the person has clearly said they're not interested in treatment and there's reason to believe that they are a danger to themselves or others or somebody else's property, or they can't care for themselves. So those are the questions that will be asked. But if, let's say, you're in fear of somebody, they've made threats towards you, or they've made threats to harm themselves, or anything like that, those are the things that will propel it to an involuntary treatment investigation.
What do you do after 72 hours?
So, thank you. I should have mentioned that too. So we make the initial decision. So the person then goes to the hospital for up to 72 hours of evaluation and treatment. What's important to remember is that at any point in time, the treating psychiatrist or psychiatric nurse practitioner does have the right to discharge a person. So if they disagree with the decision, if they've come up with a better plan, if, I don't know, something else happens, maybe different family member shows up and says, no, I can care for them, I have time, I have a room in my house, they can come stay with me. Any of those, they can discharge the person, there's nothing we can do about it. If that is not the case, then we will come back to the hospital within the 72 hours and have a conversation with the psychiatrist or nurse practitioner and determine if there needs to be a court hearing to determine if the person needs to be in the hospital for up to 14 days. So then the person can either volunteer for treatment, or they'll be discharged if they're well enough, or there will be a court hearing and then a judge will decide on whether they should be released or whether they'll be held for up to 14 days. And then after the 14 days in the adult statute goes to 90 days and then to 180, same legal process.
Excellent. Thank you.
Did that answer your question, sir?
Good. And then just in terms of format, we'll hold our questions until the last part, because I've got several additional ones that I just want to work through for the base. Next one for you, Ed, maybe would be a good one. Can you describe what to expect when your family member is arrested, booked, and placed in jail? And maybe, Sheriff, you can assist in that as well.
Let's start on the law enforcement side once that individual is arrested prior to coming to the jail.
That's how he did that. So I touched on this a little bit. I mean, what's happening, what's been our practice is we look to see if a crime's been committed. because that's our number one responsibility in law enforcement. If a crime's been committed and there's public safety or there's a mandate, like under domestic violence, we make an arrest. I'm struggling with the notion that in terms of dealing with mental illness, that shouldn't be our solution. In fact, the judges up here will tell you I'm trying to put that down about number 5 or 6 in terms of what we do going forward. When we have to make an arrest on someone because a crime has been committed or there's a public safety threat, then the individual is treated like anybody else. One of the training pieces, I mentioned the CIT training that's coming out, is talking to the officers about is the family addressing mental illness while we're on scene? In other words, is there a family member saying, my son or daughter, family member has a mental illness, they're taking medication, this is their counselor, and it's really encouraging the officer to collect that information now and provide that to the jail. Because the critical piece for us is, based on some changes that have been made very recently, if the officer or deputy shows up at the jail with a lower level crime, a misdemeanor or gross misdemeanor, and the person that is being brought in presents themselves to be very, very mentally ill, unable to care for themselves, or there's also an addiction, like a heroin addiction, or some kind of health issue, we're not accepting those folks.
I'm sorry, I didn't hear that.
We're not accepting those folks. We're asking the agency that brought the person in to take them to the hospital first. Because, as Ed talked to you about, the only thing the jail has is cells. There's not a mental health facility inside the jail. It was not built that way, it was not designed that way. And in many cases what happens is an individual who has a mental illness is brought in, they can't go into general population. They can't go into a pod of 40 or 48 other people. So the only other thing we have are single individual cells, which means 23 hours in, 1 hour out. Here's the part that really upsets me about that, is that we know from lots and lots of studies that doesn't make the person better when they're finally released. And I can talk about this, but there's one example in Everett of a gentleman who gets arrested on a yearly basis 15, 16 times for illegal camping, who's homeless, has a drug addiction, and has several mental illnesses. And yet he keeps ending up in the jail because he doesn't have a support system, a family backup, and so the court has no other choice but to impose a sentence. And so what happens is, because he can't be in general population, we put him in seg housing, which means he's by himself, and when he's released, he goes right back to what he did before. And so the segue for me is, I don't know if you saw in the paper today, one of the things we're trying very desperately is to take those folks and not ever put them in a jail. Those nonviolent folks, put them in transitional housing where they get help, they get counseling, they get somebody to really focus on the idea that they're not continually in the system.
Well said, and a segue off that too is this article is The Vicious Cycle for Jail ER Inmates, which is in today's Herald. Also, ironically, New York Times today had the mentally ill behind bars. Both similar themes, both stating that the jail has been, for lack of a better term, a dumping ground for those acutely mentally ill, and the non-violent misdemeanors are those individuals that continue to come in and out of the jail. And we really don't want those individuals in the jail. We want them to have treatment. We want them to have care. I want bad guys. I mean, literally, I want the worst of the worst. Those guys that are gonna, bird one, murder one, murder two. Those are the individuals that do belong in jail. Those are the individuals that are a danger to community. They're a danger to others. Those are the individuals I want to provide medical care for. Those are the individuals I want my nurses to be seen one-on-one. Not these non-violent, misdemeanor, acutely mentally ill that are in and out of the jail sometimes 5 to 8 times a month. So one of the things that I did immediately, and actually Ty started, is he immediately found the revenue stream to add nurses, 2 nurses to booking, and a nurse on day shift and a nurse on swing shift to medical housing to deal with their opiate heroin issue. I took that a step further, toured King County Jail, Pierce County Jail, and I saw some of the unique things that they were doing. And they had some assessment forms. And the first priority, of course, was to take care of the medical liabilities. As you saw in the last few years, many issues regarding medical in Snohomish County Jail, and we've alleviated many of those issues. Still a work in progress. But we have initial contact forms. Each inmate that's brought in by an arresting officer, we're going to see them right at the door. We've got 3 nurses right there, right now in booking on swing shift, our highest volume time, Monday through Friday. We catch them, observation, medical issues, and we're asking them some brief mental health issues, anything pinpointing. If they're saying yes to a lot of these, we're going to do a more thorough assessment that Dr. Stu Andrews, our medical doctor there, has worked up. It's much thorough, goes more in depth, and there's mental health questions also revolving around this, and we get mental health involvement, nurses involved, sometimes the ARP will come down to booking. These are the kind of mechanisms that we're putting into place to catch these individuals. We did, for the first 3 months, it was a work in progress. I was down and booking every single day, but we started to turn around. We started catching medical liabilities, and nurses got really good at it. Now that the nurses are really good and strong at catching medical liabilities, we've now transcended the last 2.5, 3 months into focusing on the mental health issues, and they're getting really good at that too. We don't have any psychiatric nurses. That's something that we have made a formal request to for council a couple weeks ago. But our nurses, correctional nurses, have been doing a great job of catching those that are acutely mentally ill and working with the sergeant in booking, the lieutenant, to deny bookings. I have a video last week of a young female who's a repeat offender, nonviolent misdemeanors, active heroin user. She came in high on heroin. She's pregnant. She's been diagnosed bipolar, off her medication, just screaming ruthlessly at everyone, yelling at officers, "Don't kill my baby, don't kill my baby, don't kill my baby." So after convening, treatment team got together and we denied that booking, and unfortunately that officer was able to go right over the ER and have a county DMHP evaluation or evaluation from their social worker. I didn't follow the case after they went over the ER, but I do know that we denied that booking. The jail is not a place to care for, a humane place to care for an individual like that. So we definitely want to look out for those individuals, and we do empathetically care about them.
So Ed, what options are there for a family to advocate for their family member if they land in jail?
Sure. Well, one of the things I did initially is I gave my phone number and email to multiple groups of people. I don't have the ability to go around the clock anymore like that. So we do have a mental health team there, the jail mental health professionals, which we just offered another provisional hire on Friday too, and we have another 2 spots. So we're gearing up for 6 jail mental health professionals. Also in the budget package that we proposed to council a couple weeks ago, part of that package it's a 3-year, very responsible package. Is we propose case managers, same kind of case managers you find at 3322 Broadway Compass, where they have caseloads, where you'd be checking on them on a regular basis. You would see that. Also part of that is a psychiatric nurse that I alluded to. And I also met last week with a psychiatric ARP who's at Shelton, and he's very good psychiatric ARP, and he'd like to come on board for 3 days a week.
So let me just, the question, I don't know if you heard him ask the question. The question is, if you've got a family member in our correctional facility, what kinds of things should you expect? And right now, I think you should expect chaos from us. It's an area that is very weak. It's something that we've got to correct. We don't do a good job. If you call us and say, my son or daughter, a loved one, was arrested, and they're on this medication, and this is their counselor, we are not doing a good job of capturing that. And candidly, we can hire all the people in the world, but we've got to change our system, and that's one of the things that we're working on, is having somebody that answers on the other end, collects that information, whether Ed's there or not, but there are people that are working there around the clock, and it's something to work on, but we got a long ways to go.
Keith, I've got something to add from
Okay,
the
good.
judicial perspective as
Good.
well. One thing you may not be aware of is that when people are arrested, as the sheriff said, there are standards for, legal standards to support that arrest. When somebody's been brought into custody by Washington State Supreme Court rule, there has to be a judicial determination of probable cause to support that crime within 48 hours. So judges go to the jail on Sunday and review all of the police reports for incoming arrests to make sure that there was probable cause to support that. But that's not the hearing where your loved one is going to be present. That's a protection for them. But the arraignment is when it's going to be a public hearing. In municipal court, we have video court for our arraignments, and I'm in the courtroom, or Judge Odell, and there's a video feed back and forth to the jail. But what I have found very effective is when there are cases, and as I said in my opening remarks, where maybe I don't have enough information about the individual. The judge may or may not have time to get detailed information from you, probably not detailed information from you at that time. But there's always an attorney sitting in the courtroom at the jail with your family member. And if I'm going to arraign that person on the criminal charge and appoint counsel, guess what? You can exchange phone numbers right then and there and get that information to their defense lawyer, who will have time to get detailed information from you about your loved one, and then that defense attorney can bring it to me at any hearing, or even what we call ex parte in my chambers. So there's the whole process, which the sheriff has been addressing, and what Ed's been addressing. But the first public appearance for your family member who's been arrested is going to be the arraignment, and I think that's a great place to advocate. I've had that happen, and it's been very effective.
So in that example, somebody would find out who the public defender is and then engage with
They're
them.
right there, and I'll call them forward and say, who are you? Who are you here for? And information gets exchanged, and that's a very effective communication.
And let me tell you about the district court. Can everybody hear me? I try not to. Okay, there we go. For district court, when I see an individual who's just been arrested and booked, he or she has a hearing. It's called a probable cause hearing. And that particular hearing, there is an assigned public defender, who's a defense attorney, who's going to represent that individual. And like municipal court, it is video court. The prosecutor, the deputy prosecuting attorney, appears in the courtroom. And once there's probable cause to hold that particular individual, then what I have to determine is whether or not this individual is going to get released. And this is where the advocacy piece of it comes from. You can attend that hearing, and district court holds video hearings in the courthouse on the first floor in Department 1. And the information that I consider, because I know very little about this individual, if it's a felony arrest, then there's an agency called Office of Public Defense. That particular agency will gather information as much as they can, including that particular individual's community ties, where this individual lives, the references that the defendant is able to give, so that the pretrial services folks, the Office of Public Defense, can contact those individuals. And this information is important because it's part of the information that a judge looks at to determine release or bail being set. If there is a family member or a friend who can attend that hearing, you have an opportunity to not only talk or give information to the judge, but also to the deputy prosecuting attorney, if you wish. And there's also a defense attorney at the jail, but you can also give that information right away after the hearing. And within that 72-hour hold, the prosecutor's office will make a decision to charge that individual with a crime or not. If they're not charged, and that individual will get released if he or she is still in custody. If they're charged later on, your advocacy does not stop. It still continues, because that particular case can, if it's a gross misdemeanor or misdemeanor, can come into mental health court. So your opportunity to give important information just continues throughout. So I would urge you to kind of look at how the case proceeds through the system, and at what point in time can you give appropriate and very useful information either through the attorney or to the prosecutor's office or to the court.
Good, that's excellent. Thank you.
Can I add one more?
Sure.
So I also wanted to add that in human services where I work, we also have 2 mental health professionals that are jail transition. They're our jail transition team. So in the morning, they will look at the list of who's been booked into jail and who's currently enrolled in mental health services, and will then notify the case manager at the mental health agency and ask them to make contact with the mental health professionals that Ed supervises to make sure they can talk about what medications the person is on, if any, or what kind of needs they might have. And then in addition, they also take referrals from families or from public defense or from the mental health professionals in the jail if a loved one is in jail and may need mental health services. And then their main function is to connect them with ongoing services, so to work with the individual until they can hand them off to a mental health agency for ongoing treatment. So that's also a good resource to be aware of.
Excellent. So that's a good segue to the next question, which had the mic down the other end there. What criteria, so you guys can share this one, what criteria must a mentally ill individual in crisis meet to be considered to enter mental health court or the Everett Municipal Court of Community Justice County?
We have some very specific criteria because, as I mentioned earlier, consistency is important. But the first finding is kind of an individualized finding, which is this person going to benefit from our program? We have some offenses that are presumed ineligible. DUI is not an eligible crime for our program, or it's presumed ineligible. In other words, I'll consider it, but it's likely not going to be accepted. And domestic violence crimes where the victim has an objection, and serious, we have actually some pretty serious misdemeanor crimes. Anything where a firearm was used or displayed, probably we aren't going to accept in our program. If somebody has been charged with a crime of violence, or they have a significant history of violent crime, we will potentially accept them into the program, but there's going to be a lot more scrutiny because public safety is really our top mission. So we're going to need a professional assessment of what issues are going on underneath the surface and a treatment plan that is something that the person is amenable to and that makes sense given the circumstances.
What if they're not amenable to it?
I think we're taking questions at the end, but if they're not amenable to it, probably we would not accept them. They have to be competent. I'm sure you're familiar with the initial determination of competency when somebody has mental illness and one of the parties or the judge on his or her own motion raises the issue of competency to stand trial. And if you have questions about that, we can maybe talk about that after, but this is separate than that. You can't have people, it's not an either or. You can't be incompetent and go through one of these programs. You're just not in the criminal justice system at all if you're not competent. And obviously anyone who presents any kind of a safety risk to the team. But as I said, we have over a dozen participants and they have really presented well in our court and done very well, and they're all very individual. And so the criteria are fixed somewhat, but we're pretty flexible, and that brings in the team approach where the team discusses the week before the calendar to come and what our expectations are.
So for the mental health court, it's primarily gross misdemeanor and misdemeanors. Felonies will be looked at, and this will depend on the prosecutor's office charging and disposition standards. So they have their own criteria and standard that they look at. So generally, if it's a charge that they feel that the disposition can be reduced from a felony to a gross misdemeanor and misdemeanor, and and then they go through their charging standards, then they'll green light the felony. But it's very much up to the prosecutor's office in terms of largely felonies. For the gross misdemeanors, let me go back. In terms of felonies, there's certain crimes that will be presumed ineligible. Your sex offenses, serious violent offenses, firearm offenses, so those are not likely you're going to expect to see in mental health court. When you get down to the gross misdemeanor crimes, domestic violence offenses, the victim must okay. That's something that the prosecutor's office, and well taken, that they would like to see that the victim is okay with this participant to be in mental health court. In terms of other criteria, you have to have an Axis 1 diagnosis, and you have to be amenable. Judge Van Slyke touched upon amenability. Amenability means that the individual, wants to participate in mental health court. There's a lot of expectations and responsibilities. You're expected to go to court very regularly. You're expected to engage in a treatment plan that the team will discuss in terms of what's appropriate. In that determination, of course, the team relies on the professionals and the current therapists or counselors or whatever mental health services that individual is connected to. That's
So can you just delve a little bit more into the expectations of the court? I mean, you touched on that just, I don't know if there's a line, bulleted list of compliance items that an individual needs to adhere to? Or?
Well, once the team, first of all, the team consists of the deputy prosecuting attorney, the defense attorney, myself, and the mental health professional. We discuss the case, and then once they say this person is an appropriate candidate, then that person is invited to observe mental health court proceeding twice, just to make sure that, is this what you really want to do? And once that person has, after 2 court observations, and it may be more, it may be a person that requires more than just 2 observations, but 2 observations is the very minimum. And this person would choose to opt into mental health court. And there's a stipulation, there's a document that person signs with the assistance of counsel. There are, contained in that documents are rights that that individual will give up. One of the important rights is you're not going to be having a trial because you are agreeing to participate in mental health court, and you're foregoing the typical process that this case is going to be going through. And the typical process is a adversarial process, that is a trial. And then there are certain general expectations and duties, keep yourself in terms of well-being. Don't harm yourself, no weapons, no drugs, no non-prescribed drugs, no controlled substances, no alcohol, meet with your counselor as required, attend all treatment sessions, attend all court sessions, etc. So those very general expectations are all outlined, and the individual is expected to initialize each and every one of them. If there is a violation, or if the individual deviates from that stipulation or a contract, and I go through that with that individual at the very beginning to make sure that this is what the court expects of you, and are you willing to agree to these terms and to follow it? If the individual violates any of those terms, before sanctions are imposed, that particular case gets discussed with the team. And so everybody gets to weigh in, and everybody, in terms of the deputy prosecuting attorney, the defense attorney, and the mental health professional, discusses what is the appropriate sanction. Is it more frequent court hearings? Is it writing in a journal about what led up to your conduct, i.e. why you missed the treatment sessions? So it varies. Jail is the reserve for the most serious violations. So before jail is considered, the team considers every other possible alternatives.
So somebody would be under this program for 6 months, a year, or 2 years?
It's a 2-year program.
2-year program.
The phases are phased out in every 4 months. It's been my observation that, of course, every case is different, every individual is different, every individual has a different diagnosis and treatment plan, what kind of treatment services, what kind of community support they have. So it's been my observation that each phase, although it is set out as 4 months each, it oftentimes takes the individual longer than just 4 months to go through each phase. And as I indicated earlier, each phase builds on each other. So if you're not successful in phase 1, you're not going to be recognized and to go to phase 2.
And then upon graduation, what is the charges reduced?
Dismissed.
Dismissed. Okay. I think that's all the questions I had for here. Now I'd like to just open it up to folks in the audience.
Keith, have them repeat.
Okay.
Have them repeat the question.
What's that?
Oh, you're going to mic.
Yeah.
Thanks for showing up, Senator McCoy.
Thank you. I found this very interesting, very informative. I've been working in mental health just about the whole time I've been in the legislature. And I've been looking into the involuntary commitments issues the last few months. But, so I'm interested in knowing, the sheriff had mentioned about we need to do something about doing harm to oneself or somebody else. And what kind of language are you looking for to help with that? Okay. I'm going to give you all my card, so I'm not expecting an answer now.
Oh, I have one.
All right, okay. Thank you for that. And then the situation about Judge Tui on the, you know, I had a constituent. He was an alcoholic. And he did no harm to anybody. He just wandered around, always under the influence. But he had this quirk that he had 10 of my campaign signs, of which he always put in the same place every other year. And he guarded them 10 signs. He made sure they stayed up and visible. And he would always tell me where they were and all that. But, you know, every now and then he'd wind up because he fell asleep out on the sidewalk or whatever, and he was taken in. And after a week or so, then he would be back at home with his parents. But, you know, he just did that. You know, he was totally nonviolent. And he knew he was going to die from liver damage because of his alcohol. So I would like to sit down and have coffee with you and talk about that kind of thing. You know, some sort of program where you have this type of individual, but in a program where you might provide them that little bit just to maintain, and they're not, you know, just blitzed, you know, just maintained and they're stable. So that's something I'd like to just sit down and have coffee around it.
And we're just beginning to look at cases, co-occurring cases, because as everybody knows, when you deal with a case in mental health court, it is just not mental health issues. It is a there's other issues that come with it. There's chemical dependency is likely, more than likely, going to be there. So we are looking at those cases in terms of, all right, how do we address this particular individual? Do we have an integrated approach in terms of having both types of treatment? I know the integrated approach is gaining steam in terms of the laws that address that. Do we address the chemical dependency part of it first and then focus on the mental health? So there is a recognition that those type of cases are more than just the norm. We see it, and so we are developing criteria and to more appropriately and effectively address that. Now, having said that, the criteria, what we do with it, is only as good as the community resources that are out there. You're going to have housing piece in place. You're going to have treatment component in place, which is crucial. And yes, coffee.
Let me try over here. I think you've been patient.
Yeah.
Do you have a question?
I do.
Okay.
Okay, I'd like to, can everybody hear me all right? Okay. I have a son who is currently incarcerated in Monroe. He's in the Special Offenders Unit. He has been locked up there for 3 years. Prior to that, he was locked up in Walla Walla for 3 years. His crime, he walked into a restaurant down in Tacoma in 2008 in June, walked up to a table of 7 people and said, "This is a stick-up, give me your money." He didn't have a weapon, he didn't hurt anybody. When they called the police, he just sat down and waited to be arrested. He was put in Pierce County Jail. They put him in Western State Hospital. He had 8 psychiatric evaluations showing that he had schizophrenia. We tried repetitively to talk to his public defender, and they never returned our phone calls, never got back in touch with us. After locking him up for 15 months and refusing to let him plead not guilty, he basically was told, "You're going to get bounced back and forth from Pierce County Jail to Western State Hospital until you plead guilty to 7 counts of attempted robbery." So Jonathan finally pled guilty. He was sentenced to 4 years in prison at Walla Walla, one of the worst prisons in this country. No recognition that he had schizophrenia. And the last 3 months that he was there, they did not give him his medicine. He freaked out, attacked 2 guards, and he got saddled with 3 more years in prison. He's going to get out the first week in June. And again, I don't believe he's getting his medication because he's really freaking out. He's really paranoid. Now, my question to you is this. With all that you've talked about this evening, and all this wonderful program that you've installed here in Snohomish County, if the same situation took place in Everett, and Jonathan walked into a nice restaurant and walked up to a table of 7 people and said, "This is a stick-up, give me your money." Now, Jonathan's a very handsome young man. He's 41, 42 years old now. He spent the last 6 years in prison, arrested when he was 36. Prior to that, he was bounced back and forth from Snohomish County Jail to home, back and forth, Pierce County Jail to home. And so he got sick when he was about 26 years old. The last 15 years have been hell for him. It's been hell for his family. My question is, if the same thing happened now, how different would it be for Jonathan if he walked up in a nice restaurant in Everett or anywhere in Snohomish County and said, "This is a stick-up, give me your money"? No weapons involved, no force is applied. What would happen? I'd really like to know.
No, let me start.
As you can tell, I'm very, very angry.
Yeah, no, that's very clear. And I can tell you that the story that you've given is, I could repeat over and over again from other families that I've met with, and why I think there needs to be such renewed call for changes. It is not, you'll hear me say this as long as I have breath, this is not a public safety issue. This is a societal issue. So let me just talk for a second. The question that you asked is, we've talked about all this great stuff we're trying to do, what about your son here in Snow County? And candidly, I think very similarly things would happen. And here's why. If somebody makes a threat of violence, it's a stick-up, just like somebody walking into a bank and saying, this is a stick-up, here's a note, not armed, doesn't have a weapon at all, and gets money, we treat that as a felony. If you've heard us talking a little bit today, the felony pieces in this state still require action under the law for public safety. So we don't have as much freedom. So what it really comes down to is those 7 people sitting around the table. What was going through their mind? Did they really feel that they were about to be robbed? Did they give anything up? In other words, did they give up their wallets or watches? You didn't mention that in the story,
No.
so I'm assuming that didn't happen.
No,
and
instead
so
one of the party pulled a gun on Jonathan.
I think my hope is that we're trying to change how we look at that event. In other words, that what you described as somebody calling out for help. Somebody absolutely needs help, and I defer to Corolla or the judges. I don't believe the type of response you got from the public defender in Pierce County is at all what we're expecting from our public defender system in Snohomish County. One of the things that's changed greatly in the state of Washington since your son was arrested and tried is the state Supreme Court has required that public defenders get a lot more help. So their caseload is a lot more manageable now, which allows us to have kind of the program that the 2 judges described. In other words, having families be able to talk to public defenders. But very candidly, the same type of response would be exactly what your son experienced. In other words, if somebody picks up the phone and calls 911 and says, we have somebody in the restaurant trying to rob a group of individuals, the police are going to respond as if it's somebody that's armed and it's a very violent call. And it's up to them to get there and determine that it's really a cry for help. I'm going to pass it down to the judges.
I did want to say one last thing. A similar case like this happened a couple weeks ago. There wasn't a gun involved, but there was a punching of a nurse. It happened in a healthcare facility, so that's automatically an assault 3. I was notified of this. I had 2 booking nurses immediately assess this individual. I had a jail mental health professional assess. Together as a treatment team, we made a synopsis. This is not a violent individual that needs years and years and years of prison, 90-day orders to Western State, competency after competency. No, this person immediately needs to go back to a psychiatric hospital. So one of the great things that we have now set up is the prosecutors on board with looking at all avenues, similar angles that Ty just mentioned, to say, is this really a violent individual, or is this an individual that is psychologically unstable and needs a psychiatric hospital? So what I did immediately is I called DPA, prosecuting attorney Ed Stemler, Tricia Stemler. Within 2 hours, they were back in court, and they got a release order, and then a DMHP and Corolla's team detained that individual and went to a psychiatric hospital. So that's the kind of proactive approach that we're taking now. Just back-to-back, doing what's right for the inmate to try to get them back into a psychiatric care facility and not this cycle of Western State prison.
I think one of the things that we are focused on in terms of what I see slowly changing is when an individual goes through the system, that individual is going to have his or her case looked at by many different entities as it progresses through the system. So therefore, there has to be a working together and collaborative effort in terms of how you look at this particular case, whether it be the prosecutor's office, the defense attorney, how that information is conveyed to the court, and how the judge, the Western state, the reports, etc. So it's not a one isolated piece, because we all have to look at the information as a whole in order for us to make the best decision that we can. I will tell you that the vast majority of referrals to mental health court comes from the public defender's office, because they are the ones that are the first line in terms of touching and meeting and touching on the defendant's case, meeting with the defendant, talking about it, seeing this is giving them advice, etc. So I will tell you that the Snohomish County Public Defender's Office is very good at being very active. And then to the prosecutor's office, very good at engaging in that conversation, because this is not going to work unless that conversation is had, in that both sides has an open and approaching these types of cases with an open mind, rather than having that traditional hat that the prosecutor's office has on, or the traditional hat that the public defender has on. Because these cases are processed differently. Therefore, we have to kind of like take a step back and say, all right, we got to look at these cases differently in order for this to work.
Jean?
Hi, my name's Jean Hughes, and I just want to say thank you to all of you who came tonight, and to the first four sitting there. I want to say I'm sorry I have been bugging you so much and annoying you, because I know for sure that I have, and I have a couple things that I really wanted to thank you for. I just want to say that you do an awesome job. And I thank you, because the 4 times that I've had to call the sheriffs out, they were very helpful. I also want to say that to Corolla, I thank you for the job that you and your staff do, because I know it's not an easy job.
Thank you.
And they've always been great. However, the VOA, I mean, I could call and say anything, and they do not send anybody out.
What's the BOA?
VOA, Volunteers of America, they dispatch the CDMHPs. And I was told when my son left Compass, that if he wasn't compliant with his meds, all I needed to do was to call the VOA and ask them to revoke his LR. And that has never happened. He's still at home. He still doesn't take his meds. Every day for me is hell, because it puts such a, and I think a lot of people in your positions, you know, do the best you can with what you got when you've got it to work with it. But it's extremely stressful on the families. And for me, I get no information at all from anybody about anything, because my son won't sign an ROI. And so that would be my thing to work around. Ed, I want to tell you that I did speak with you about my son. He came to jail wearing a $75 pair of blue shoes. That's some expensive skateboarder brand, and you were going to look for them, but I guess you never found them.
I did not find them. I had my property sergeant look for them.
I know, and I even went there looking for them myself, because they were a gift. But I will say, on this note, I cried like a baby when he came home from jail, because I felt so bad for him. And he said, "But Mom, they were really nice to me there." And, wait, one more. And Judge Tambui, my son was in your court, I believe on the 21st, Friday the 21st. I tried to give information to his public defender, and honest to Pete, they were rude when I called the office and said, I'm sorry, this case doesn't involve you and we can't tell you anything. And I said, I don't want to know anything. I want to give you information. He's mentally ill. He's non-medicated. And, you know, I want you to have that information. Fortunately, when I finally got in touch with Rachel at that hearing, they did delay it until April 18th. And so what I'm hoping for is that something positive will come out of that for him. But anyway, thanks to all of you for coming.
Hello, my name is Eric. I was curious if I have a loved one that goes, the sheriff talked about violent situations, but what if we have a case where a loved one goes in peacefully and or is committed to a crime where the mental health court he doesn't follow in that program. What can I do to ensure that our loved one gets the proper medication, it's followed through? I've heard horror stories that it doesn't happen, you don't get any response, and they're just left.
Who do we contact?
Yeah, who do we contact? How do we
When you
follow
call the
through?
jail, you can't get through to nobody.
Yeah, so I don't need the microphone if everybody can hear me. I get accused of all the time being a loudmouth. I talked about this earlier. It's a huge gap for us. I mean, we recognize it's a problem. We need to be able to collect information. We fight the idea of HIPAA all the time. You know, if I were king for a day, the HIPAA law would be one of the first laws I'd get rid of, quite frankly. I realize it does good stuff. I'm sure there's lots of reason for it, but it really does create a lot of issues for us in terms of what we can say or do or talk about. But we are working working behind the scenes to create a system for Family Line, for families to be able to call in and talk to supervisors, to provide information. We're just not there yet.
Yeah, that's what scares us, because we're the only reason he takes his meds. If he's incarcerated, it won't happen. Right. And we love your help for that. He has to do his time, but he's going to deteriorate. Just like you talked in the beginning, you don't want that.
We don't.
And honestly, reoccurring over and over and over, it's a cost issue. You don't. Well,
it's a cost issue, yes, but we're supposed to be the most progressive country in the world, and yet we incarcerate more people than any other country, and we've been doing that for a long time, and it hasn't worked. And so I really think it's time we look around and say we got to stop repeating a bad practice. It's not going to change overnight, as I mentioned early on. If there was a simple or a process that an entity could use, it would have been discovered by now. I have talked with Akron, Ohio officials. I've talked with Dallas County, Texas officials, because those are two areas who really are kind of being touted as geographical locations that are doing it better than most. But candidly, you know, they will still tell you there is a lot of work to be done. And so when I say we want a Family Line, we do. We want 100 other things that we recognize that needs to be fixed. It just takes time.
So you don't actually have a line, or who do we call? Who do we call?
You can call during the business day and ask to speak to somebody. But
Ask to speak to who?
Well, there's a.
Go ahead. Yeah.
So there's a jail mental health office, and that's 425-388-3092. I can also write that
we'd
down.
love to have those kind of numbers. We don't have the situation, but it could be pending soon.
Yeah.
So we want to be proactive.
Yeah. So yes,
We're advocating for our son to make sure he is properly treated.
Here's the problem, and I'm probably speaking too globally. We do have phone numbers, but we don't tell anybody what those numbers are. So one of the things that we've got to do with our website is you've got to be able to go to our website, and if you have specific things, we've got to be able to tell you, call this number. It doesn't do us any good to show up in a meeting full of folks and say, yeah, we've got this number, when we're not telling the population around the county what the number is.
Can you give us that number one more time, please? Yeah.
425-388-3092. And Ty's right, we're working on the website right now because we need direct numbers, we need direct links, we need to separate nurses, MHPs, classification. That's the kind of separation that we're working on. Clear communication.
One more question to Corolla. My son has been state committed in King County and Snohomish County twice. It's been a year since he's been out. He's doing great. My question to you, since he has had 3 where he stayed almost a month, is he in the system now? If he was to be picked up on the street or something and you pull up, his name's Bolton Heverly, are you going to see that he has a mental health problem? Does it state, does the sheriff, do you see that when you pull him up?
No. It's
Okay.
one of the problems with our
That's
system.
one thing.
We don't get a flag that tells us your son has had mental health referrals, because that falls under the medical law and therefore it's private information.
That'd be something that would really help, I think.
For us, if we get a referral, to come see him, let's say he's in an emergency room, or if you were to call from your house, he would be in our database and also at the crisis line, so we would know, and we have a chart, and then we could look up, when he was last seen and whether he was committed and whether he's enrolled right now, so we can and do look all that up before we go see somebody.
And to the sheriff, one more question.
Yes, ma'am.
Thank you for doing the CIT training, because I live in unincorporated Snohomish County, Martha Lake. The sheriffs don't want to deal with it. They ask me, what do we do?
Yeah.
They have no idea where I live, so I don't call them. I'm used to calling like Jacob Taylor or somebody from the DMHPs, and they come out to my home, but I understand there's a new thing that you have to call the VOA. You don't call the 388-7215 anymore.
So VOA, the crisis line, they've always taken our calls at night, and they're now taking them 24/7.
And then they notify you?
Right, yeah, so we're on call 24/7, just like we've always been.
Because I've had the they just come right out to the house.
Right, yeah.
They like it.
And I really, if you experience, like Gina, I appreciate you saying that, and we had actually a discussion about that in an earlier meeting today in the local group. If you experience difficulties with that, where you see a difference, like, earlier we came out right away and now we don't, please call me or email me and let me know, so then we can address it. Because we don't want a deterioration there at all. We just, we're looking for streamlining and providing the same service across the region, but if it's not working for people who live here, then that's not a good thing, and we want to fix it.
So
Can I ask a real quick time check? So we're about out of time. Take maybe 3 more questions.
Can I answer that question in the criminal context? If your son goes through the criminal context, when the court looks at it and at the time of hearing, we will rely on information that's gathered from at the time of arrest. So that's where this training piece comes in, is that if law enforcement picks up certain mental health issues, or during the booking process, if that is laid out in a document, then the court has that information. If you show up at the hearing, you can give that information to the court. There's a deputy prosecuting attorney there, so you can give that information to the court. So it's a system where if we're going to make effective changes, every single entity is going to have to work together and get that information, so that if it lands in the court system, then the court looks at it. It's a civil context. And
good. Michael?
Sheriff, one of the things that we teach a class for parents and caregivers of mentally ill. We've actually prepared a script for the folks that call 911 to say to the person, this is a mental health case, this is mental health, and I give you my phone number. Could you have the officer that's coming call on his way? And quite often that de-escalates a lot of the stuff you're talking about.
Perfect. Because we work what many people don't realize is the 911 system, the place where you call and it dispatches us, is not a function of the sheriff's office or the Everett Police Department. It is its own entity who hires and trains folks who work off a script. And so when somebody calls from a restaurant and says there's a robbery in progress, that automatically triggers a response that can't be undone. They've taken the thinking, unfortunately, out of dispatching, so that is perfect.
Well, Jeff Ross told us
He's a great guy.
what to say with the CIT. May I have a few seconds too? We have now started, like he said, we teach a class to parents of mentally ill youth and adolescents. We have now started, they've been doing it in New York City to all the teachers since '09. We are now starting to teach professionals. We're hoping to get probation officers, CPS, foster people. It's called Professional Basics, and it is a curriculum out of NAMI. It's not something we've made up in our head. It's a 6-inch binder. And we're trying to put together the classes plus teaching the schools. But I have flyers, and if you're trying to get your people trained or to know something about mental illness, this goes through the different mental illnesses and
it's a 15-hour class.
It's a 15-hour class. So,
Excellent. You had a question. You were very
Yeah,
patient.
I just want to, and I want to comment to it. As I heard a lot about, leading up to something's about to happen, and if your loved one has federal insurance, they have an access to services line that you can call before they get to this point. And I want to say it's 425-212-7900, but I don't remember off the top of my head exactly. I work, my question is, I work with the Sheriff's Department to outreach mentally ill homeless through 211. I don't know if you're familiar with that program.
Yes, ma'am.
So my question is, what are you doing with maybe the sheriffs and maybe even the other law enforcement in the area to teach like tolerance? Like, it's kind of a hot or cold, like sometimes it's the chore that no one wants to do.
Yeah.
And then sometimes you get really positive response.
The question, and this is my soapbox. The question is, what are we doing about mentally ill homeless folks, especially in law enforcement in Snohomish County? We're not doing a very good job. What we do is we treat it as a community policing problem. Best example I can give is a business owner walks in the morning, sees a homeless person sleeping in the doorway of the business, gets very upset because they see a loss of income, calls the mayor's office, calls the county executive. That leads to phone calls to the police chief or the sheriff. We turn that into a community policing project, and guess what? We go out and find a reason to arrest that individual because the only system that we really use on a regular basis is what I've been saying all night long is we arrest them and take them to the jail. We have to stop that. We have to stop that. I'm a big believer in if I say something's bad to come in with a solution. I don't have the solution to that problem, but I can tell you we've been doing it for a really long time, and what I can assure you is the problem's only getting worse. It's not getting better. And so moving forward, there has to be a lot more conversations like this. There have to be legislators, there have to be local elected folks, and an assortment of panelists just like this looking at one step at a time, what do we do differently? I feel like we're finally getting the attention this issue deserves, and little by little, we're taking it one bite at a time, we're going to change it. Do I expect that in my tenure, I'll see a wholesale change? Absolutely not. But I do believe it's getting better.
I'd like to make a comment. You said that you don't know exactly what the answer to these problems are, but I think that it's going to require money. Sure. A considerable amount of money. Sure. Instead of building a new courthouse, why don't we use that money for the people? Huh? I mean, the people are a hell of a lot more important than some fancy schmancy offices for civil servants.
Everett School District did that.
So I can't answer that question, ma'am, because I'm not involved in that process at all. I do agree it's going to cost money. I think there are significant issues that we're facing. Not only do we have the education piece, we've got some other stuff. I'm not a big believer in let's spend our way out of the problem. I think we got to take a look at what can we change, what can we affect right away, and develop a 5- and 10-year plan. That probably is going to involve spending money, but I don't think the first start is we need another bucket of money. I think the first thing we need to start doing is talking. And that's why I think things like this are important.
What about suicide?
You know what?
Sue in the case of suicide. I'm a bipolar alcoholic and I worry about friends on the support group. And if they mention there's like warning signs, I mean, who do we contact if we're worried about that, but we don't want to betray their trust for telling us things? I'm not saying anyone's actively suicidal. I'm just worried in a hypothetical situation that someone perhaps will. Yeah.
I would start by calling the crisis line. You know, the VOA, they have mental health professionals on call 24/7, and talk it over with them and get some guidance on, you know, whether there's a voluntary mental health team in Snohomish County and a voluntary trained team, which I supervise, kind of if an intervention might be appropriate, or just to maybe get some referrals for somebody you're concerned for, that kind of thing. Yeah.
What do you do with a family member that refuses to get mental help, refuses to even believe they are sick when they are? What do you do with that person?
Well, it depends. You know, in this state, the way the laws are written, a person has the right to be mentally ill as long as they're not endangering themselves or anybody else. So it really depends on the acuity of their symptoms and whether they're threatening harm to self or others, or whether they can take care of themselves. But just the mental illness that, you know, although it might be obvious to everybody else that they would benefit from treatment, is not alone enough.
How can we leave this up to them? They're like a computer with a bad software, and they're expected to fix themselves.
That's not cool, man. Say that.
I think it's
not cool, but it's
I'm mentally ill and I don't refer to myself as a computer with that hard.
I understand that. But what I'm saying is these people are left to make the decisions for themselves when they're mentally ill.
I think that, you know, definitely in Washington State, the statute reflects that people are allowed to make their own decisions, whether the rest of us agree with it or not, or whether just because I think something's better for somebody or they should live a different lifestyle doesn't mean they should, as long as they're not harming themselves or anybody else, and that's the way our laws are written.
Okay, but once they're in the system, once they're in the prison system lets them make the choice if they get mental health or not. Monroe, okay? Right now my son's in there, okay? And they're letting him make the decisions. They're going just like you're doing. Well, it's his choice, okay? Now he's to the point in Monroe, in the prison system, it's time for him to get out. He's going, I don't want out. I want to stay here.
Yeah, it's a tough situation. I think the reality is what we've heard, we have to break for time and wrap things up. The reality of what we've heard tonight is a lot of encouragement. You know, we all know that, you know, there's a history of the system not working as well as it could. And I think, you know, I personally am impressed by the dedication of these folks and the trajectory or the trend that's in place for the future. So at this time, I'd like to just thank the panelists, you know, maybe a round of applause. It's obvious that they're all, you know, big-hearted individuals, and I think this is, like I said earlier, probably the first of many meetings to go into the future. So again, I'd like to thank them as well as you for showing up. I mean, this is the kind of, like Ty was talking about, it's a comprehensive, community-involved interaction that's called for to make change. So with that said, I wanted to give a special thanks to Kimberly Miller, who's not here, who was instrumental in organizing this event. And I also wanted to encourage you to get some snacks, get some information, visit our websites for additional information. Feel free to talk to the panelists until they leave. And also we're accepting donations to help offset the expenses for this event. So thank you very much for showing up.